The Court of Appeal has reserved judgment on an appeal filed by the leader of the Indigenous People of Biafra, Nnamdi Kanu, who is seeking to dismiss the terrorism and treasonable felony charges preferred against him by the federal government. A three-member panel led by Justice Jumai Hanatu, after listening to both parties, said it will now communicate a date for the judgment to them. TVC News Judiciary correspondent Celestina Area reports.
The IPOB leader, who is currently facing trial before the Federal High Court in Abuja, had, through his team of lawyers led by Michael Zekome, senior advocate of Nigeria, approached the appellate court to challenge the legal competence of the charge pending against him. He specifically prayed the appellate court to review the April 8 ruling of the trial court, which struck out only 8 out of the 15-count charge. He insisted that the charge entered against him has no basis in law and appealed for it to be discharged and acquitted. Mr. Kanu equally urged the appellate court to order his release on bail pending the determination of his appeal. Though the appeal was initially fixed for 11th October, following an application he filed for abridgment of time, the appellate court brought the matter forward for hearing. When the matter was called up, a 3-man panel led by Justice Jumai Hanatu said it had no need to delve into the issue of bail since the substantive appeal was ripe for hearing. Arguing the appeal, Michael Zekome alleged that his client was forcefully abducted from Kenya and legally renditioned back to the country. He told the court that his client was first arraigned on December 23, 2015 and was later granted bail on April 25, 2017. Meanwhile, the federal government, through its lawyer David Kwesa, urged the court to dismiss the appeal for want of merit. He maintained that IPOB leader was brought back to the country by due process of the law. He argued that the charge has been amended 7 times owing to the conduct of the appellant. Justice Hanatu told parties that when judgment is ready, a date to be communicated to parties.
Has no case against him at all. He is being kept in detention by the same DSS who investigated him, the same DSS who arrested him, the same DSS is detaining him.
Are you saying our people don't have a right to complain? Are you saying that the government that we pay tax to is not supposed to address those grievances?
One of the grounds of Mr. Kanu's appeal was anchored on the doctrine of speciality as provided in Section 15 of the Extradition Act, that the federal government ought to have proceeded to try Mr. Kanu on the initial 5-count charge he was facing before he escaped from the country. Celestina Area, TVC News, Abuja.